Okay, everybody. Well, good afternoon, and thank you to SPACE for asking me to provide this taster talk today. So, welcome to those in the room and also to those people who are online. What I'm asking today is a question in criminal law, and my name is Robert Jago. I'm a professor at the University of London, but I also am a visiting lecturer for Hong Kong U SPACE, so teach criminal law as well as public law. And the question I'm asking today, particularly about the criminal law, is when should a failure to act attract criminal liability? Now, why is this a live issue now? Because actually this is an ongoing question that's asked every year of all students in criminal law as to why or whether a failure to act should actually attract criminal liability. And one of the reasons it was particularly live this year, this academic year, was because we had a recent case back in December 2023 of a gentleman called Ryan Johnston. And basically he raped a woman in front of other passengers on the London Underground. Now the complexity about this case was that this woman was unconscious, and this rape took place on the London Underground, and there were question marks as to why more people didn't intervene. Why didn't people do something? What were the obligations that were on people to do anything, and should there have been more obligations on people to do anything? In the case itself, what happened was actually a French tourist witnessed the crime, and they were on holiday in London with their child, and they witnessed the offence, and so they reported it to the police. But the question, of course, that came out of this was it was a particularly unpleasant incident, obviously, but the question was, should there be a legal duty to intervene? Because this is not the first time where questions have been asked about why more people don't intervene when they see crimes happening. And what are the obligations on people when they witness a crime? What should they do? So what are the expectations? Are people expected to sort of run in and try and break things up to help people who are perhaps victims of crime? Or is there simply a duty to perhaps contact the emergency services, the police, etc.? And they're the sort of questions that are asked as to whether there should be a more general legal duty to intervene. And therefore what that would mean is if you do have a legal duty to intervene, then should people be held criminally liable if they fail to act? Now the question, of course, for the courts has long been this idea about is there a difference between an act, which is something somebody positively does, and an omission, which is something which somebody fails to do. So if I positively do something, that could be seen as an action, whereas if I fail to do something, the law says, well, actually, that's an omission. And in some respects, this is illustrated, and the complexity around this issue is illustrated by cases such as in hospitals, where if you switch off a ventilator, so somebody's very poorly, they're on a ventilator, they're probably not going to survive. If you switch off a ventilator, is that seen as a positive action, because you've got to push a button, or is it seen as an omission, because you're failing to do something? Well, most people would probably understand as soon as you switch off something, it's like switching on the light, that of course is a positive action, so that's an act. Well, what about if you want to discontinue medical treatment? So somebody's got medical treatment and you decide actually when the treatment drip stops or the bag is empty, at what point does the law say that that's no longer an action, but it's actually an omission? And the discontinuance of a drip feed, for example, by withdrawing the tube, or failure to replace an emptied drip bag, both of these are questions as to whether they would be acts or omissions. And it's quite complicated because the courts have had to grapple with some of these questions in quite difficult and emotional cases. And one such case was back in 1993, and it was the case of Anthony Bland, and that's an example of a case citation. So it's the Airedale NHS Trust, which is the hospital, versus Anthony Bland. And what they were doing was trying to understand that Anthony Bland himself had been a victim of a footballing disaster back in the late 80s. He'd been on life support and ventilation for a long time, and the hospital applied to the court to say, look, can we actually withdraw treatment from him? There is no chance he will wake up. There is no chance of long-term survival, so can we withdraw treatment from him so that we can basically let him pass away with dignity, and also his family were very supportive of them doing that. But of course, if the courts take a view that if you do something positively, then as soon as you switch off a life support machine, the question was, well, is the doctor then going to be held liable for murder? Because they know by switching off the life support machine that the person is going to die. So what the court said was, the hospital said to the court, look, we're not trying to commit euthanasia here. That's not our aim. But what we're trying to do is to understand from the court whether it is possible for us to be given permission to stop treating him. So that we can say, look, you talk about acts and omissions, but what we're particularly interested in is understanding whether we will be held liable should we stop treating him. And what they wanted to do was to remove a nasogastric tube that was actually feeding him and keeping him alive. And the House of Lords in the case, after much deliberation, because obviously it's a very sad case, they decided that actually ceasing to treat Anthony Bland constituted an omission. And because it constituted an omission, the law takes a very different view about what is an action, a positive action, and what is an omission, which is a failure to do something. And they said, because this is an omission, there is no murder, and there is no manslaughter, because there is no guilty action. There is no actus reus of the offence. And so students in criminal law are faced very often with these sorts of questions about whether something is an act or whether it's an omission, and whether criminal liability should be imposed as a result of that. Now, the way in which that's the issue about act and omission, and when we talk about failing to act, the criminal law language is omission. So when do people have a legal duty to actually do something? When does the law require them to do something? Well, the interesting question about when does a failure to act attract criminal liability is that the general rule in English law is that there is no criminal liability for omissions. So I can walk around England and Wales, back in the UK, I could see a child drowning in a pond, I could see somebody dying in the street, and there is no legal obligation on me to do anything. Now, of course, there may be a moral obligation, and of course, very often people would perhaps think, oh yes, I'm going to help, I'll summon help, I'll get somebody to help, even if I can't help. But there's no legal obligation. And what that means is that the law says, look, you don't have to do anything, unless you are, for example, a lifeguard. So if you're a lifeguard and somebody was drowning in a swimming pool, then you could be liable for an omission. Because basically you have a duty to do something because of your contract of employment. And it's this duty basis which the courts focus on in trying to narrow the scope of liability for people's failure to act. Because after all, if the argument is that if you have a very wide duty to act, then when do you stop prosecuting people? Say all of the people in this room walk on by while someone's drowning. Are you all to be prosecuted because somebody's drowning and you don't do anything? And that's the question that's often asked in criminal law, is whether the law ought to impose a much wider obligation than it currently does. So what does the law do? Well, it bases everything around this duty, and it identifies particular examples where people will have a duty to do something. And the first of these is when the statute says you have a duty. And the most common example that's often cited is where we have specific statutory offences. So for example, the one I've identified here is section 6.4 of the Road Traffic Act 1988, which is if you're stopped by a policeman and the policeman suspects, wonders why you were driving erratically, for example, and they think, oh, actually, I suspect you're driving under the influence of alcohol, then there is a duty. They will say to you, look, would you mind blowing into this bag, please? And if the person refuses to do that, then they will say, look, you're potentially guilty of this offence of failing to provide a breath specimen. We can't do our job as policemen in checking the alcohol in your breath unless you blow into this bag. So the argument is that you have this duty because the law says specifically in statute that you have this duty. So that's one example. Now another example is where the law has said that there is a special relationship in existence. So what do these special relationships look like? Well, they might be, for example, between a parent and a child. And this is illustrated best by an old case from 1918 called Gibbons and Proctor. So in the case of Gibbons and Proctor, Walter Gibbons lived with his partner, Edith Proctor, and they had a little girl called Nellie. Now they basically starved Nellie. They neglected her and she starved to death. As a result, the court said, well, you are going to be held responsible for murder, and the way in which your guilty action is constructed is because you had a duty, because there is a special relationship between a parent and a child, which, especially if the child is a young child, the child relies on their parent to feed them, to water them, to keep them safe. So if there's a failure in some way which results in the child's death, then it's possible, and in this particular case it was obvious that they were deliberately withholding food from her, it is possible that they could be found guilty of murder, and indeed they were. And for Walter Gibbons, it was on the basis that he had this special relationship with his daughter Nellie. What about husband and wife then? Well, the criminal law says actually, according to the case of Smith in 1979, that actually the legal duty which is owed by one spouse to another is not to do with a special relationship. It's to do with something called a voluntary assumption of responsibility, which I will talk about in a moment. And that's because basically people who marry each other are both adults, and because they're adults, the expectation is you voluntarily assume a responsibility towards your spouse because you married them. But the interesting thing that's made clear in the case is that if you are a couple who, for example, are still married, but you are separated, then you wouldn't have any legal duty to each other. Because the whole point about the duty is because you're married, and you live together, you work together, you do various activities together. So if you've decided to separate, then the point is the criminal law says, well, on that basis, you no longer owe a duty. And the courts wouldn't expect you, for example, to hold the same level of duty for somebody who you no longer wish to be with, because obviously you've separated. But the key thing is to say is it's about voluntary assumption of responsibility. And then the last of the special relationships that are considered by the courts here is the doctor-patient. Now, I mentioned the Bland case earlier, and in that case, the courts make it clear that the duty which doctors owe to their patients is basically to act in their best interests. Now, of course, best interest can mean many things to many people, but there will be a collective view on what the best interest will be. It will rely very heavily on medical opinion, and the House of Lords said that in the Bland case, Anthony Bland no longer had any interest in being kept alive because he couldn't function. He was brainstem dead, and he was no longer able to function. The only thing that was keeping him breathing was basically the ventilator, plus, of course, this nasogastric tube, which was feeding him. And as soon as they took that away, he was essentially waste away because he wasn't receiving any nutrients. But what they said was to discontinue treating him would not violate what was in his best interests. Now that's quite controversial, because people will say, well, hang on a minute, surely it's in your best interest to stay alive, to be kept alive. But the court said no, because there's no prospect he can recover. He's in a persistent vegetative state. And because he's in a persistent vegetative state, there is no way in which it's possible for him to continue to live a fruitful, happy life in the way that obviously he did when he was a football fan, and as a result they decided to discontinue treating him. But they said very clearly there that that special relationship could include a doctor-patient relationship. You then have this voluntary assumption of responsibility that I've already mentioned. And again, we go back to the case of Gibbons and Proctor. Now, just as Walter Gibbons' duty was based around the special relationship he had with his daughter, Edith Proctor, who was the Walter Gibbons' partner, she was not the mother of Nellie. But what they said was actually she had voluntarily assumed a responsibility towards Nellie because she undertook a legal duty to ensure that children were properly fed. So therefore she was criminally liable, just as Walter Gibbons was, but the duty basis is different. For Walter Gibbons, it was because of the special relationship, but for Edith Proctor, it was because of a voluntary assumption of responsibility. A later example of voluntary assumption of responsibility comes from the case of Stone and Dobinson. Now in Stone and Dobinson, Michael Stone's sister Fanny, who was in her 60s and very, very poorly, she came to live with Stone and Dobinson, and they basically failed to protect her. So they took her into their home. She was very ill, they knew she was very ill. They did try to summon some help, but they didn't do it very successfully. And the reason I've included a telephone there is there's a famous example in the case where it says that they had some developmental delays, some learning difficulties, and then they didn't know how to use the telephone. So they went to sort of the local telephone, tried to use it, couldn't use it properly. And this failure, this general failure to get any help meant that Fanny died. Now the court said, look, the duty basis, everybody's an adult. It's not on the basis of a special relationship. But what it is on the basis of is a voluntary assumption of responsibility. And it provides another example of where voluntary assumption of responsibility becomes critical when you talk about duty basis for omissions liability. The problem with the case is what we ask in criminal law is, well, they did try. So what standard do they have to get to in order to discharge their duty? They sort of tried to summon a doctor, they didn't quite know how to do it properly. They tried to ring for medical help using the telephone, they didn't know how to do it properly. It's a whole catalogue of errors, this case. But there are question marks about the quality of assistance that's provided, and that's what needs to be remembered. The next duty is reasonably straightforward. It's where it's contractual. And the leading case for contractual duty is the case of Pickwood. Now, Pickwood was in charge of the station, and it was his job to actually lower the boundaries when obviously the trains were coming along. So he was supposed to lower the barriers when the trains come along. He failed to do that, and just as a train came along, so did a hay cart. There's an accident and somebody's killed. Now, he failed in his contractual duty. He failed to lower the barriers. That's what's expected of his role. And therefore, the court said his duty is imposed by his contract of employment. But clearly, this duty will depend on the terms of the particular contract. The next duty is a more recent creation, and this is where somebody basically creates the dangerous situation themselves. And the leading case here is the case of Miller. Now, Miller was a vagrant, or some people would historically talk about a homeless person, a tramp. And he basically decided went into a house, was squatting in this particular house. He was lying on an old mattress. He was smoking. He fell asleep. When he woke up, the mattress was on fire. Instead of summoning help, he just went to the next room, and the house burned down. Now, he didn't die, so therefore the question was, well, actually, is he liable? Because he could have summoned help. And the court said that actually we are going to impose a legal duty on Miller, because arguably he created the dangerous situation in the first place. He was smoking, and he fell asleep, and the mattress caught fire. Now, of course, you might say, well, what was he supposed to do? Was he supposed to try and put the fire out? And the court said no. He didn't need to do that, but he needed to summon help. He needed to ask for help. He'd created the dangerous situation. However inadvertently he'd done it, he didn't deliberately do it, but he had been reckless by smoking near the mattress, and therefore the court said, well, sorry, you owe a duty to rectify the danger you created. And so the courts have created this idea of dangerous situation to try and impose duties on people and say, look, it's not enough to simply say, I don't owe anybody a duty, because in this circumstance, they said, look, you created the danger, there is an obligation on you to do something. You don't put yourself at risk, you don't have to run into burning buildings, but because you created the dangerous situation, there is an expectation that you would actually take steps to resolve the problem. And then the final example is what we call the doctrine of continuing acts. And this is illustrated by the case of Fagan. Now in Fagan, he was driving a Mini, little car. Policeman pulls him over. As Fagan comes along driving, he actually ends up parking the car on the policeman's foot. The policeman is obviously hurting at this stage, because you have a car on your foot, it hurts. He says, please remove the car from my foot. And Fagan says, no, I won't remove the car from your foot. Now, he said at the time, look, when I parked the car on the foot, I didn't intend to do it. I wasn't reckless, it just happened. So therefore, you can't suggest I'm guilty of a criminal offence. And the court said, no, this is a continuing action here. And the point at which you said, no, I won't remove the car, is the point at which we actually apply this Miller principle. You created the danger or the inconvenience or the pain. your driving led to the car being placed on the policeman's foot. And because you, at that point, you've created this situation, I'm afraid, therefore, it's seen as a continuing action, and when you decided that you would not remove the car from the policeman's foot, that's when you become liable for your failure to act. So it's not about the fact you put the car on the policeman's foot in the first place, it's the fact you failed to remove the car when you were specifically asked to. Now, what does that tell us? They're the duties. Well, it tells us that the overarching themes that emerge in this failure to act is this idea of reliance. In each of those scenarios, each of those duties, the courts are looking for reliance. So if you are a young child and you've got parents and you live with your parents, the child relies on you to obviously look after them, to keep them safe, etc., to feed them. If you voluntarily assume a responsibility, maybe you're doing it, which means other people aren't. And that again is about reliance. If it's your job to do something, to save people in a swimming pool because you're a lifeguard, or to lower the barriers when the trains are crossing, that's your contractual obligation. And it's what the courts are looking for, is reliance. And of course, the argument is, in the context of dangerous situation, continuing acts, you've created the danger, therefore we rely on you to do something in order to end the problem that's been identified. So whether it's the car on the foot, the burning building, etc. Now, the last question I want to ask then is, when should a failure to act attract criminal liability? Because on the one hand, we have the Ryan Johnston case, which has led to this question again being asked. But we also, should a failure to act, should it attract criminal liability? And two academics have had an argument about this. The first one, back in 1989, was Professor Andrew Ashworth, and he said actually this law is not fit for purpose. He said we should actually have much more obligation to each other than what's called the social responsibility view. He says that we should adopt what we call easy rescue statutes, which they have in other parts of Europe. So for example, if you don't do something, then you can be fined because there is a duty on you by statute to do it. So for example, in France, in Italy, in Germany, all of those countries have easy rescue statutes. And it means that you basically have to pay a fine if a policeman decides you should have done something and you didn't. Professor Glanville Williams, then in 1991, said no. He supports the conventional view. And he said actually we should maintain this very restrictive basis, because he says the problem with your easy rescue statutes is it places an obligation on everybody. Whereas for us, our system in the UK, and certainly in England and Wales, he says is limits very specifically the incidents when the duty will be imposed. And that's the point about the duty basis. Now, depending on what you think about this, and this is what we discuss in classes in criminal law, it's basically up to you to decide. You either like what we have and think it's restrictive, but actually, you know, people do come forward. If people are drowning, people do save people. Do you need a legal obligation to do that? Right? But at the same time, you might think actually this might encourage people to be more socially responsible if the law says actually you do have to do something, otherwise you risk being fined. Okay? Thank you very much.
Thank you very much. That was very informative. Do you have any questions for us? Any questions? Any questions? I mean, you don't see him every day. He flew all the way from UK to Hong Kong here. So if not, then Rob has to go to our class.
I do.
Yeah,
What's class?
you do. So thank you.
I don't think we've got any.
Yeah.
There's no messages here, is there, on the line? So.
Do you have any questions for Rob?
I have a question. So with the case of the guy who went squatting into the cigarette incident, let's say if he actually got help and the house still burned out, is he still?
No. The courts would say, I mean, they would say, look, well, they may have said he was reckless, so they may have said, actually, you're still responsible because you fell asleep and you know, the place burned down. But they would have based the liability on a different purpose. They would have said, look, you did get help, and so we're not basing it on the duty basis, we're just looking at the criminal damage, and potentially you were reckless because you shouldn't have been smoking, etc. But it wouldn't be on, if they did find him liable, it wouldn't be because he failed to do something, because obviously he did do something, he summoned help.
Any other questions?
Yes.
the case